Good afternoon, everyone. I would like to welcome everyone back to day 2 of the UWC German Exchange Program. My name is Albizo Buchholz. I am a lecturer and a doctoral researcher in the Department of Private Law. I'd also like to extend a warm welcome to the HMP of Private Law, Dr. Yun. It is such a pleasure to welcome our colleagues from the PhD program at the University of Berlin. And I'm sincerely excited for the presentations that will be happening today. So today we can expect 2 workshops. The very first one will deal with protecting human rights in global supply chains. Each presentation will have 20 minutes from the presenters, and then 10 minutes will be dedicated to questions from the floor. Okay. I will then ask also that the presenters just briefly just give their names before starting their presentation. Thank you so much.
Yeah, thanks a lot for this warm welcome, and we are very happy to hold this workshop today. Just as I said, to briefly introduce ourselves, my name is Vidas. I'm a PhD researcher and research assistant at the chair for civil procedure and private international law. So Peter Abu, who's also in the room with us today.
Yeah, my name is Rodriga. I'm very pleased to meet you all. Hello, I'm a PhD student too at the chair of the Degrees Level and I'm to civil procedure. My name is Franziska. I'm from the same chair. My interests lie also in private international law, and I feel extremely honored to be here today and to present our workshop for you guys. Thank you so much.
Right. Without further ado, I would say that we get right into the topic. The topic of today's first workshop is going to be the protection of human rights in global supply chains, as you can see. And to first of all get an idea of the practical implications of this topic, I would like to introduce you to a great case study, which is from the UK, but also from the Netherlands. And the case study deals with Royal Dutch Shell, a public limited company in Nigeria. And Royal Dutch Shell is a British Dutch corporation, so it has its main seat on one hand in the UK, but also in the Netherlands. And it is operating a joint venture in Nigeria. Now, this joint venture is composed by, on one hand, Royal Dutch Shell and also Nigerian state-owned companies. And the joint venture is operating a subsidiary with the name SPDC, which is a short form for Shell Petroleum Development Company of Nigeria, also a limited company. Now, this subsidiary is the operating corporation of the joint venture, and what they've been doing for over 50 years is that they've been exploring oil in the Niger Delta region. Now, this business has been quite successful for these 50 years, but what happened after some time is quite tragic, since because of their business operations, these caused oil spills in the region, and this tremendously affected the environment in the region. Now, not only was it the environment, but also the health and general quality of life and the living standard of the people living there. So the inhabitants were tremendously affected. They couldn't use the water anymore since it was exposed to elevated levels of petroleum hydrocarbons, and this also affected the quality of soil and the air. Now, because of that, well, first of all, maybe just a quick picture of what was happening here. So what you can see here is one part of the Niger Delta, and especially the shadowy and blurry parts within the water is the oil running through the Niger Delta, which made the water in the Niger Delta unusable for the inhabitants of the areas. It is no surprise that the inhabitants and one might say victims or affected people in that region actually filed claims because of these actions happening. And they initiated legal proceedings in front of European courts. Now, in the UK, in front of the Supreme Court of the UK, it was the case of Barbie and others versus Royal Dutch Shell. So it was a proceeding against the parent corporation having its seat in the UK. And the claimants were, I think it was around 42,000 inhabitants of that area, which were affected by the oil spills. A very similar proceeding was held in the Netherlands by Milieu Defensie, which is a very well-known NGO in the European legislative framework. And what they did is they supported Babu and others, which were full fishermen of the region and couldn't operate their businesses anymore. And they also filed a claim against Royal Dutch Shell also in the year 2021. Now, what they based their claim on was that they argued, since we have the parent corporation and its subsidiary, that it would be the parent corporation having its seat in the European country, which breached their duty of care with regard to the operation of its subsidiary. Now, this is a very specific case, and what I would like to do to get an idea of what we're talking about is just taking a step back and looking at the abstract constellation of cases we're looking at. So what we usually have is, as I introduced, one European parent corporation, Royal Dutch Shell, having its seat in the Netherlands or the UK. Then we have a subsidiary, or at least a contracting partner with sufficient contractual relationships, having its seat in a non-European state. And what happens on a factual level is usually that there's a human rights violation, or at least environmental damage with human rights dimensions, happening in the non-European state. And this is caused by operating businesses of the subsidiary and the actions taken or omissions taken by the subsidiary. And the question that lies at the heart of the whole topic of global supply chains and the human rights protection within global supply chains is, can we create any sort of liability of the European parent corporation for the actions and omissions, and especially the human rights violations, along their supply chains, which were, in the first step, initiated by their subsidiaries?
I will take over from here, because with this topic of responsibility of corporations for human rights violations in different parts of the world, I'll try to use the microphone just a little bit more. The responsibility of corporations for the violations of human rights and environmental standards first came into the picture of the global discussion in 2011 with the United Nations Guiding Principles on Business and Human Rights, which is a soft law, non-binding contract. And then in 2022, the German Supply Chain Due Diligence Act, nice German word, Lieferketten-Sorgfaltspflichtengesetz, which introduced this soft law from the UN Guiding Principles into binding law for German corporations and companies falling into the scope of this law. And also in 2023, the EU Corporate Sustainability Due Diligence Directive, which CSDDD directive. So on a European level as well, an introduction of a binding legal act to have corporations be responsible for human rights and environmental damages in different parts of the world. What happens with these legislative acts is that European companies who are covered by the scope of these acts become obligated to take responsibility for violations of human rights and environmental standards all along their supply chains. The legislative acts put a due diligence firstly to identify, prevent, and mitigate the risks of violations of human rights and environmental standards within the entire supply chains, meaning that the violation and the risk of violation of one of these rights can happen from raw material sourcing until the selling of the end product, who is the product of the global supply chain. The obligations that these legislative acts put on the companies include ones to conduct risk assessments, to implement preventive and corrective actions against violations of both human rights standards and environmental standards. Companies are also further obligated to report on all the measures they're taking to follow these due diligence obligations, and they have to install a grievance mechanism if individuals or communities in different parts of the world are affected by violations such as human rights or environmental standards violations. Furthermore, the companies are also obligated to discipline legal independent entities, both their subsidiaries and their suppliers, beyond what were the pre-existing organizational boundaries along the supply chains. Meaning, European parent companies are bound by these acts to a degree that the risk assessments and all the preventive measures they have to take apply beyond their own factual sphere and extend these obligations also to their subsidiaries and suppliers of actions, meaning that, and this is one of the most important steps of these legislative acts, meaning that the companies are no longer able to claim their ignorance or their non-acting regarding human rights violations, both requisites for later liability of the companies for violations along the supply chains. Having now presented the general problem of liability of companies for human rights violations and the legislative acts in regards to this, now the colleague Gesine would like to present one of the main and core challenges of all supply chain due diligence law. So I'll pass over to you.
Thank you very much, Franziska. Once it has been agreed that European companies must be held responsible for the violation of human rights in global supply chains, the question arises whether the enforcement mechanism should be public or private. Public enforcement hereby means that authorities ensure the compliance of companies through measures such as imposing penalties, maybe fines, or doing investigations. Right now, many countries in Europe rely on a public enforcement mechanisms. You can see a few examples here: the UK, the Netherlands, Norway, Switzerland, but also for today, very important, Germany with its Supply Chain Due Diligence Act of 2023, where the enforcement model was heavily discussed, with companies in particular being against a private enforcement mechanism, but ultimately it was agreed that Germany should only use a public enforcement mechanism. In contrast, we have private enforcement. Private enforcement means that individuals, so maybe the people affected in the third state or victims, NGOs, bring civil claims directly against the company and enforce the law. France stands out, having introduced a private enforcement mechanism in 2017 with its Loi de Vigilance. So here you can see another picture. I hope it's clear what the difference is between public and private enforcement. The preference for one of the two enforcement mechanisms is debated in legal literature, and I would now like to present the arguments for and against the two mechanisms, which will hopefully serve as a fruitful foundation for our discussion. So public enforcement, let's take a closer look at its advantages and disadvantages, starting with the pros. So one significant advantage of public enforcement is actually that in theory, public authorities can easily be granted far-reaching powers. A good example for this is also Germany. Under this law, authorities have the power to summon individuals, mandate corrective action plans from the companies, and impose penalties on those that fail to comply with their obligations. However, public enforcement also has several drawbacks. First, there is the issue of effectiveness. While penalties may influence company behavior in the future, they do not provide fair compensation for victims of corporate misconduct, which should be one of the big aims and goals of human rights protection in global supply chains. Second, there are several enforcement deficits. Even though I said that in theory, authorities can be granted far-reaching powers, right now, in fact, authorities often lack sufficient enforcement powers, especially when it comes to foreign companies. Establishing facts abroad can be particularly challenging because the authority people, the officials, they must fly over there and establish the fact, and this makes it difficult to obtain necessary evidence. Additionally, many authorities do not have the capacity to investigate each case thoroughly, and a shortage of staff and a potential lack of motivation also weaken the enforcement efforts. Unlike private actors, so maybe the people affected in the third state, public officials may have no personal incentive to push for a strong enforcement. Third, a comprehensive enforcement is resource intensive. Authorities need significant financial resources. This money comes from taxpayers. So from an economic perspective, full-scale enforcement is often impractical because it's too expensive and also unrealistic to implement on a large scale. This brings me to the last point. Public enforcement creates a dependency on NGOs because, as I just said, as the authorities lack the needed powers to establish facts abroad, NGOs are needed, which often fill these gaps by raising awareness, supporting the investigations, and advocating for the victims' rights. All right, so now let's move on to private enforcement. Again, in this model, individuals or NGOs bring claims directly against companies. Starting with the pros again, generally spoken, victims are the better claimants. they often have a strong personal incentive to pursue claims because they are directly affected. They are likely to have the key information about liability and damages, which is crucial for building a strong case. And additionally, NGOs, which are often the people, the company, the organization who actually pursues the claim, are usually agile and efficient in litigation and often driving cases forward quickly and effectively. However, private enforcement also has several drawbacks. First, there is a dependency on the procedural framework of the country where the claim shall be pursued. This includes the availability of funding to cover the legal costs, rules on cost allocation, options for collective litigation, access to information and evidence, which is especially important when it's in the possession of the company, so the possible defendant. And finally, the enforcement of judgment, which can be challenging, especially across borders. This also leads to the second point, which is a disadvantage of private enforcement, the legal uncertainty. This is especially true in international cases where it can be difficult to determine which law actually applies. Then there is a very important point. The victims, so the people affected, often face numerous obstacles. These include geographical barriers, financial constraints, lack of information, and psychological challenges that can discourage the people affected from pursuing claims. This creates a significant power imbalance between the potential claimant and the potential defendant, because while the claimants often lack the financial resources to pursue legal action in another jurisdiction and are usually unexperienced in legal matters, companies benefit from extensive legal and financial resources. This also leads to the third disadvantage of private enforcement, which is exactly the same as it is in public enforcement models. We have a dependency on NGOs as well, because as I just said, NGOs often act as the real driving force behind claims, but they are pursuing the cases as part of a broader public awareness campaign, rather than solely for individual compensation, which should be a goal of human rights protection as well. This approach, known as strategic litigation, may not always align with the victim's personal goals. Yeah, so in conclusion, of course, the challenge remains finding a balanced and effective approach. The discussion about the advantages and disadvantages often of the enforcement mechanisms show that the global nature of the issues in particular creates different hurdles. In reality, we often have a combination of both mechanisms, something that also happens on a European level with Article 29 of the CSDDD, which Franziska just presented to you. But both mechanisms in the end rely on NGOs. So our question is, if you think that international cooperation should play a bigger role in enforcing human rights laws and global supply chains, but of course, we're also happy to hear other thoughts and suggestions, maybe questions. Thank you for your time.
Can you hear me? Yeah. Your presentation was quite insightful and also very timely. So from my side, I think what I found interesting was the regulations on due diligence for companies. So I wanted to know whether you think that those regulations and restricting due diligence for companies are actually effective, and if not, what type of, barriers do you think still exist in implementing the due diligence regulation? From my side, and then obviously we'll ask a couple of questions from the floor.
You want us to like?
Yes, go around and then
Yes.
there we go. Any questions for our presenters? Or any comments even?
Mine is a comment. It's
Yes.
It's actually interesting that earlier on we were talking about you as linking me up with colleagues who are involved in corporate law. And it turns out that actually you may be the right people to work with us on the research that you are doing, which is quite interesting. It really touches on what we call corporate law as here. And it's very interesting to us look at human rights violations by companies and the responsibility of a parent company for the offenses of its subsidiaries. Quite an interesting aspect. And I think the challenge will always be on enforcement, which is why I can see that between private and public, you're not sure whether it should be a combination, but it has to be a combination because it's very difficult to achieve success through one way. I wanted to ask whether, looking at the fact that the EU, unlike other regions, it really does have a framework which ties in, for example, with the United Nations frameworks which are there. As, for example, you has referred to the UN guiding principles on business and human rights. I'm sure it ties in with the regulations that the EU has. I just wanted to find out from you. I need to talk about what can be done by the nation where the parent company is registered. Is there any enforcement that you think should be done at EU level or at United Nations level, or do you think that it is NGOs that have to enforce that? Is there anything that, for example, the EU can do? Because I think when companies come from the from Europe and they do business in Africa, sometimes it does taint the image of the EU. Because there are some things which those companies, the parent companies, cannot do in Europe, but they seem to easily do it in Africa, for example. Is there any enforcement mechanism that could come, for example, from within the EU framework? Can the EU enforce measures against parent companies that are based in Europe? I just wanted you to think about that, and also to touch on whether the draft norms of the UN can ever be enforced at EU level to ensure that you increase the liability of parent companies for the offenses of its subsidiaries. Okay.
Thank you so much, Prof. Any other comments, questions, presenters? We can just allow them to answer.
We can just.
Just start here, maybe.
Pardon?
Maybe we can start and answer these two questions.
Yeah,
and then
of
move
course.
on.
Of course, we might answer.
Yeah, thank you for these very insightful questions. And I think they're also quite connected. So you also mentioned that enforcement is such a big issue, which is also the reason why we actually focus on this matter. And it was also part of the legislative process in saying that specifically nations being quite skeptical of the principle of human rights obligations, and especially along supply chains, argue that, okay, it is rather idealistic to frame certain obligations and to say a parent corporation in the EU has to do X, Y, Z in the third state, that we cannot really enforce it. But at the end of the day, I think it really comes down to the question that we asked ourselves at the end, saying that maybe it is about the cooperation and the international cooperation of authorities. Since at the end of the day, it's just a procedural matter. It's about taking up evidence. It's about bringing the claims actually forward in European courts. And this is something that, in my personal opinion also, the European legislative framework has to work a lot more on, and that they have to improve the framework in. And yeah, maybe leading to your question, it's quite interesting that you're mentioning the UN guiding principles and human rights protection, since they were actually also a big deal in the legislative process, and not only the national legislature in Germany, from my knowledge, but also the European legislature put it into the preamble of their laws, saying that they actually want to comply with these UN guiding principles. So they saw the issue that at the end of the day, it's only guiding principles. So it's soft law. It's great to apply them, and it's great to respect them, but they don't have any obligatory nature for the nations. But this is what the European legislator did. They say it is of such importance to us that we actually put it into an obligatory framework that our corporations have to comply with. And this also leads me to your second point about the enforcement and the European legislative framework having an effect on the European parent corporations. What the European legislator and the national legislator in Germany did is they said, okay, we cannot really enforce any obligations upon subsidiaries and corporations from third states, which is, as I understood, you have a background in corporate law, also founded in the principle of legal entities and the separation of legal entities, which totally makes sense. So what they did is they said, okay, we have the European parent corporation under our legal framework, and what we say is, at least we give them some obligations that we ourselves can control. So we take preventive measures, we take risk assessments, and we take something they actually have control over, without saying that they have a strict liability for every human rights violation happening at the subsidiaries level. And this is how they somehow got along the issue of enforcement and of especially extraterritorial legislation, in saying that we concentrate on the companies that have a seat in our jurisdiction, and we oblige them to act accordingly, and especially to respect the UN guiding principles. So, yeah. Thank you.
Thank you so much, colleagues. Any questions? I think,
Mine is just a comment, first to congratulate the team for the wonderful presentation, and to say that it will be interesting, maybe in your research, as your research evolves, to be interesting to see how the policy at the European level, of course, the law in Germany, how it ties into, or how it fits with the African policy on business and African Union policy on business and human rights, and the African Human Rights Commission resolution on business and human rights. I mean, it will be interesting to see how those the resolution of that policy fits with what is happening in Europe, especially since most of the victims of human rights violation by these international corporations are in that particular area of the country. So I just wanted to point that out.
Yeah, thank you. Also, your comment for me, it ties a bit into what your first question was, because what these legislative acts on the German and on the European level want to achieve as well, with the due diligence character of the legislation compared to a strict liability approach, many different arguments against one and the other, etc. But what they also want to do is that they start at the risk point. So they already look at the risk of a violation of an environmental standard or of human rights, and they do not start at the moment of the violation itself. So the due diligence comes in the perfect world, it would come like before the violation even occurred, to really not only give victims of violations the possibility to better their situation, but to more broadly protect human rights in general, also at the stage of risk assessment before these violations occur, which I don't know if from the African perspective that you just took, if that's also an aim that is in line with what the perspective that you just talked about is taking as well.
Okay, so I was simply just pointing out, I'm not an expert in this field. I was simply just pointing out the fact that those the resolution, the African Commission on Human Rights resolution of business and human rights exists, and also the African Union's policy of business and human rights exists. So, and I'm saying that as a researcher, it'd be interesting to see how as your research evolves, it'll be interesting to see how those policies speak to what's happening in other words, what are the parallels, if at all, what are the convergent points, if at all, between policies on the African continent for business and human rights and what is happening in the world. That's just the point.
Yeah, very interesting.
Okay, so we're running a bit behind time, so thank you so much, colleagues, for your insights. We appreciate that. And we're all good to go. Take the presenters to the stage, and they will present on intellectual property and impact on global health. I was told that this presentation will look at the intersection between IP and access to medicine and medical innovations. Once again, I want to remind the presenters 20 minutes for presentation and then 10 minutes will be dedicated to questions from the floor. Thank you.
Right, thank you for the kind introduction. We are very pleased to stand here today and also excited to present our perspective on this issue we're presenting today, intellectual property and its impact on global health. And yeah, in today's presentation, we want to go deeper in that aspect. We are members of the chair of Professor Dr. Axel Metzger, and Nadia, Lucas, and me will talk about this issue in more depth. And yeah, firstly, one might ask himself in that regard, what is global health exactly? And slides.
Is it on?
I don't know, is it on? It is not. I hope now it is. So what is global health as a first thought? And therefore there is a definition that it is the area of study, research and practice that places a priority in health worldwide. And in today's presentation, we also want to set a priority to health security, which are the activities required, both proactive and reactive, to minimize the danger of acute health risks, acute health events. And that is the main question, I guess, in the presentation. How could intellectual property rights, how could they be a part to solve these issues? And therefore, we can take a glance in the TRIPS agreement, especially in Article 7, which outlines what I would say to be the main goals of intellectual property. On the one hand, the promotion of technological innovation, and on the other hand, the transfer and dissemination of technology. And on the first half of these effects, Lucas is going to talk about the supplementary protection certificates, especially they're called SPCs in short, and they are a special EU instrument that is able to extend the protection of pharmaceuticals after the patent has expired. And also he is going to talk about the concept of further medical use and as a way to increase the innovation incentives. And on the other hand, when we see the transfer and dissemination of technology, Nadia is going to talk about compulsory licensing. Normally, it is the best way that licensing is being voluntarily, but in some points, and especially kind of in acute public health events, it could be necessary to have compulsory licensing, and that's what we're going to talk about. And then I hand over to Lucas.
Yes, so I'm going to start speaking about the promotion of technology innovation. And generally, the idea is of promoting a technological process through patent law to develop new medical treatments and pharmaceuticals to combat global health crisis and to treat commonly known diseases. So the general idea of patent law is to create an incentive from the prospect of an exclusive right, and this exclusive right should give a monopoly for the patentee over a period of time, enabling them to amortize their development costs and the cost for development and to generate profits. Generally, in the European Union as well in Germany, you can receive patent protection for all kinds of manufacturing processes, substances and compositions. So finally for pharmaceuticals and also for medical devices. I think this is common patent law and more or less on the basis of the TRIPS agreement. This is obviously important that all those innovations only gain access of patent protection when they apply to the requirements, the patent requirements, and namely they need to be new and they need to involve an inventive step. It's also important that we don't offer patent protection for methods of treatment of the human body, for example, by surgery or by therapy, and also by diagnostic methods. And this is in regard to guarantee the freedom of doctors to choose their medical treatment in the case of emergency. Interestingly, in Germany, we have a special regime that offers kind of further patent protection for special pharmaceutical innovation, and it's called the further medical use. And it's regulated in Article 54 of the EPC, the European Patent Convention, and it's more or less an exception to the requirement of novelty, which an innovation need to apply to be patented. And the general idea of this further medical use is that even if there is a substance or a composition that is already known before, that's part of the technology, can also be patented as long as the medical use is new to the prior art. And it's important that this law or this exception only applies to substances and compositions, so it only applies to pharmaceuticals in general. And interestingly, this law differentiates between two different types of medical use. So on the one hand, you have the first medical use, and on the other side, you have the second medical use. The first medical use describes the first discovery of an already known substance, of a chemical substance or composition for a medical procedure. And although this substance is already known, you still can receive a patent as long as its medical use is new to the state of the art. An example would be that there's maybe a commonly known substance that's called amlodipine and amlodipine. And amlodipine, a pharmaceutical company discovers that this substance can be used to treat, for example, high blood pressure in a dosage of maybe 5 to 10 micrograms for each day. So they can receive a patent for the treatment of high blood pressure with this already known chemical substance. Nevertheless, we have also an additional possibility to receive another patent with the second medical use. So the second medical use regulates that the requirement of novelty is also met when there's a substance or composition already known, but the innovation is that we find that the innovator discovers a new form of medical use. So even if the substance is already used, for example, to treat high blood pressure, the patentee can receive another patent for a new form of therapy. And a new form of therapy describes, for example, the treatment of a different disease or the treatment of a new group of patients or the change of the dosage. So to come back to my example of this amlodipine, in this case, even though it's already known that you can treat with amlodipine high blood pressure, the pharmaceutical company can receive another patent if they discover the use of amlodipine, for example, for children with a dosage of 1 to 1.5 microgram for each patient. To sum up, the general incentive that is created with this regulation is that pharmaceutical companies try to focus their research on already known substances for the use of new medical treatments, and generally or practically seen, this regime is used quite a lot to meet the requirement of novelty in the German and European patent law. Besides this regulation, the European Union offers another interesting intellectual property right that is called Supplementary Protection Certificate, or in short, SPC. And SPC is an intellectual property right that extends the protection or the patent term of a patented pharmaceutical after it expires for a maximum of 5 more years. And again, it's important that this extra or additional intellectual property right only applies to pharmaceuticals. And why do we have, or why do the European Union introduces this kind of extra intellectual property right? The objective of this regulation you can find in the recital of the regulation that is the basis for this right, because in Article 4 it says, at the moment, the period that elapses between the filing of an application for a patent for a new medicinal product and authorization to place the medicinal product on the market makes the period of effective protection under the patent insufficient to cover the investment put into research. So the idea is to create an even greater incentive for the research in pharmaceuticals that are based on substances or compositions. Interestingly, they also have another objective that they are following with this regulation, and they say in Recital 6 there exists the risk of research centers situated in member states of the European Union relocating to countries that offer greater protection. So also in regard of global competition, the European Union tries to create more incentives to keep pharmaceutical companies within the European Union by giving them an extra intellectual property right. I generally just want to show how does this extra this SPC is working, and what do they mean when they're speaking about the time to amortize their developments after the patent has filed. So on the left side, you see how generally the process of developing a pharmaceutical in the European Union continues. So it normally starts with a patent or with the application of a patent for a substance or pharmaceutical for the treatment, for example, for high blood pressure. But after that, they normally need, on average, 8 years to develop a pharmaceutical that gains a market authorization, and then finally, after 8 years, can be offered at the European market. So they lose 8 years of their patent protection while they're not able to offer that product on the European market. That means that in total, they just have 12 years left to recover all their costs for development and research and to gain profits. And the European Union said that this 12 years are not sufficient, or that they want to create even a longer period for an exclusive right. So with this SPC, the pharmaceutical company receives an additional 3 years of exclusivity. So in total, they have 15 years after the market authorization of exclusivity. However, this SPC can be even longer, to a maximum of 5 years, depending on the period of time when this patent was introduced to the market. So, and then example further below, you can see that if the development needs 10 years, they have 10 years of patent protection left, so they gain an additional 5 years of protection by the SPC. The SPC generally offers the same protection scope as a patent, but it's only focused or reduced to the use of this patent of the substance for the specific pharmaceutical that received an authorization by the administration of the European Union. So what's the takeaway of those SPCs? Generally, the European Union has the opinion or had the idea that 15 years of an exclusive right after the market authorization should provide a sufficient incentive. However, could be that also a shorter period of market of exclusivity could also be sufficient. So there is no empirical evidence that 15 years, an incentive of 15 years is necessary for protecting pharmaceuticals. And we shouldn't forget that the extension of exclusivity always comes on the cost of the interests of, for example, generic manufacturers, because they're not allowed or they need to wait this extra period of maximum 5 years to be able to replicate or to replicate this this pharmaceutical and to introduce generic. However, even if we have a longer protection for pharmaceuticals, we have special mechanisms that allow access to patent technology, and this is where I give over the microphone to Nadia.
Okay.
Yeah, thank you, Lucas. As Alvin already introduced, I'm going to speak about. Oops. I'm going to speak about compulsory licenses, and I'm going to start with Germany and then widen the perspective and talk about the European Union. So in Germany, the compulsory license is contained in section 24 of the German Patent Act, and it can be claimed by third parties as potential licensees, and is granted by the court, which decides upon the granting of the compulsory license. And to illustrate the German mechanism of compulsory licenses, I wanted to talk about the one case where compulsory license was actually successfully granted, which is the Reite-Glavier case. And just to briefly state the facts of the case, there was a treatment for HIV marketed on the German market, but this treatment infringed upon a patent of the Japanese firm. And so they sued the marketing company for infringement. And the company who marketed the HIV treatment started licensing negotiations and wanted to license the treatment. However, the Japanese firm refused to license it, which would have meant that some patients, German patients, would have to switch to another treatment with potential side effects. And even though it was only a very small amount of patients affected, actually pregnant women and children under 6, the Federal Court of Justice held that this suffices to supersede the interests of the patent holder. So in this case, as I said, the only case there was actually a compulsory license granted. So what you can take away from this case is that the granting of a compulsory license is generally linked to the public interest, and that the public interest has to prevail over the interests of the patent holder. As I mentioned, this is the only case where a compulsory license was successfully granted. However, this does not necessarily mean that the mechanism is ineffective, because we don't know how it influences licensing negotiations between the parties. So maybe parties use the threat of a compulsory license as a bargaining chip in licensing negotiation, and maybe this mechanism induces parties to actually come to voluntary agreements. However, this is difficult to prove, so we cannot take any definitive statement regarding the effectiveness of this mechanism. Regarding the legal situation in the EU, there's a patchwork of different national compulsory licensing mechanisms. So Germany is one of them. However, the different member states of the European Union have different compulsory licensing regimes. And in every member state, the compulsory license is somehow linked to the public interest, as I just have shown you for Germany. And this is intended to supply the domestic market. What does this mean? This means that the compulsory license is generally limited to the resolution of domestic issues. So it cannot be triggered by a foreign crisis in order to supply a foreign market. This is only intended to resolve crises within the European Union and the respective member state within the European Union.
Furthermore, as I've already said, the compulsory licenses have different requirements and different procedures within the different national member states, and this means, and in its effect, it covers only the respective member state. This means if you imagine a cross-border crisis, it is quite difficult and time-intensive to obtain a compulsory license for every member state in order to tackle a cross-border crisis. So this would be very time-intensive and costly for potential licensees. Thus, the European Union recognized this, and I wanted to talk about the proposal of the Union compulsory license. The triggering incident for this proposal was the COVID-19 pandemic, a cross-border crisis, and the aim of the European Union is to improve the resilience of the EU in the event of such a crisis. So it is intended to specifically resolve the second issue I just pointed out. Now, according to the Union compulsory license, we have uniform conditions for the granting of a compulsory license, and the effects of this compulsory license would cover the whole EU territory, instead of only the member state in which the compulsory license is obtained. However, this compulsory license is strictly limited to the event of crisis or an emergency mode. So we have no general union-wide compulsory license, only for the event of crisis or emergency mode. And this crisis or emergency mode, there's no abstract definition contained within the regulation, but as you can see, it would have to be activated by the European Commission in a preliminary procedure. What is interesting in this case is that it is the European Commission who is responsible for granting the compulsory license and not a court, as I have told you with regard to the German mechanism of a compulsory license. So right now, we would have a system of coexistence of the different various compulsory licenses within the member states and union-wide compulsory license, but only for the event of a cross-border crisis, which would be quite a high bar. What is interesting in the legal design of the compulsory license, so I wanted to briefly touch upon it, is that if you would imagine a COVID-19 vaccine, just to stick with that example, this usually comprises more than one patent. And it usually takes some time, or can take some time, to identify the right holder and the different patents contained within such a vaccine. This is why in this regulation, the EU enabled the possibility to identify the compulsory license by the product and not by the patent. So it would suffice to just say, I want to compulsory license the Moderna COVID-19 vaccine. And this also shows the aim of the European Union to swiftly tackle crisis. So it should really be a fast mechanism, and I think it's quite an innovative path to take for compulsory licenses. So quite interesting take of the EU. I wanted to talk about another mechanism within the EU for compulsory licenses, which is the compulsory license for the export of medicine. So the aim of this compulsory license is to address public health problems and improve access to medicines. It is intended for less developed countries which don't have the production capacities to manufacture needed medicines themselves. And so this is intended to address the first point I pointed out regarding the member states which is that compulsory licenses are only intended to resolve domestic issues. And this is intended to resolve non-domestic issues when countries are able to produce needed medicine themselves. So how does it work? If a national authority receives an application of a company which wants to manufacture and export medicine, then it can decide upon granting to such an eligible country, and the eligible countries for such an export are defined in Article 4 of this regulation. There is one successful case where this license was actually granted, which happened in 2007, so quite some time ago, from Canada to Rwanda. So within the EU framework, we don't have one successful case where this compulsory license was actually granted. And also in this case, The procedure turned out to be quite slow and cumbersome because there are also national health authorities involved. So actually, by the first time the shipment of the medicine arrived in Rwanda after 4.5 years after the granting of the compulsory license, there was already a cheaper generic version on the market. So this set quite a poor precedent for other companies to use this mechanism of compulsory license. So we suppose that companies might simply have no incentive to apply for such a compulsory license. However, we would be happy to discuss what your take is on the probably failure of this compulsory license mechanism. And we would be happy to discuss also the other points of the presentation, as this marks the end of our presentation. Thank you for your time.
Thanks for all your insights. It's truly appreciated. I think we have time for about 2 questions from the floor. Question or comment, will be welcome.
Yeah, mine is a comment, just to probably bring the discussion closer home to the South African audience. First to commend you guys for the wonderful presentation. For the benefit of those who probably don't understand what IP rights does to questions around public health. Just think about the South African case. I mean, the HIV pandemic, when it was top in the country and people were really dying. Okay, one of the challenges that the government faced was the expensive nature of the ARVs, and that was foiled by the insistence on exclusive rights that patent vested in pharmaceutical companies. Okay, so with that in mind, also think about COVID-19 experience, the difficulty for African countries, especially South Africa, to get the vaccines, to get the vaccine medical supplies for COVID-19. This were caused because of very expensive nature of the prices, which was foiled by enforcement or insistence on the right or patent rights by pharmaceutical companies. Now, compulsory license is then a mechanism provided for by patent law to help to serve as an exception, if you like, or indication to that patent right. So governments, for instance, different countries have different mechanisms which enables them to, in cases of public health crisis or in public interest, the government will take certain actions to ensure that the products, the pharmaceutical products are available. So that's what compulsory license does. I'm trying to simplify it. What's like the presentation shows is actually more complicated than that. Yeah. So in South Africa, and this is for the presenters really, what the South African government has done in the past, there are provisions for compulsory license in the South African Patent Act. But the South African government has instead taken a different route, obviously because of the challenges of implementing compulsory licensing regimes. The South African government took a different route by approaching the issue through competition. So the Competition Commission had to step in, and what's the name of that case again? The case that involved, I think, GlaxoSmithKline, the ARV case. So the Competition Commission had to start investigating cases, investigated pharmaceutical companies and came out with findings actually found in cases of abuse of dominance because of excessive pricing. And that caused the pharmaceutical companies to, they had initially refused to grant licenses for local companies to produce generics. So with the intervention of the Competition Commission, they had no choice than to come to the negotiating table. And that contributed largely in dragging down the price of ARVs in South Africa. So, I mean, the South African case is an interesting example of how governments can get around the challenges of compulsory, challenges of implementing compulsory licenses, but now through other regimes like competition. in some cases too, in South Africa, they've also approached it through through human rights provision, obviously because the constitution has provisions for the right to health. So these are some of the nuances I thought I should bring up in South Africa. Thank you. Actually, a comment.
On Prof's comment, I was also looking to gain your thoughts on what do you think can be, you said there's a lack of incentives for companies to obviously engage in compulsory licenses. So what do you think are some of the incentives that could potentially be offered in the future?
So, yes, the problem or the general problem with the IP law and the patent law is that it's only one part of a very complex world. So, as you said, there are also, as Prof. Desmond also said, there are many ways to tackle health crisis, and many ways, many pieces of law to deal with this problem or with this issue. I think generally we should incentivize technology transfer. And obviously, patent creates one barrier that has to be broken to facilitate technology transfer. However, I have the feeling, or at least that is a European perspective on this problem, is also that pharmaceutical companies mainly act in the private sector. So their goal is to gain profits, and normally in global north or in Europe and the United States, the prices for some vaccines for pharmaceuticals, the government can pay much more higher prices. And that's why they focus their research on those fields rather than transferring the technology to other countries, which cannot pay the same prices. So I think also this market mechanism that we have generally in the field of research for pharmaceuticals is one challenge or one main problem while we have this uneven take on research.
Just a quick remark. What I also found in my research for this presentation is that also voluntary mechanisms are quite fruitful, but not like the regular bilateral negotiations. But I found the medicine patent pool turned out to be quite successful in some ways by negotiating with the right holders and then sub-licensing to African companies who can build up their own manufacturing capacities. So it turned out to be, I think, a more sustainable way than just a compulsory license or maybe the export. So I found it quite an interesting take, but yeah, I'm also not sure what is the perfect solution for this problem.
I was just going to say something about compulsory licensing being something which not necessarily being used that much, even if it is available as a capability under the trade agreement. So my question is, do you think that the pandemic treaty would then be a much better approach in terms of addressing challenges, for example, that we experienced with the COVID-19 pandemic and all the other pandemics? So basically, does the answer lie in IP and the kids, or the licensing is provided under the EU, or maybe the pandemic treaty might actually be the answer? What would be your take just in general? What would be your view regarding the pandemic treaty under the World Health Organization?
So I think you would need a measure on world level, like something like TRIPS, to ensure that price license is actually granted, because the EU mechanisms are somehow tied to the territory of the EU, so they cannot be this fruitful. But I think what we as European countries took away from COVID-19 was also that the incentive of IP is quite important. So if more compulsory licenses would be granted, firms may not have the incentive to research and to manufacture such vaccines. So I think from our side, it also was quite interesting to see how fast vaccines were researched, and this in part is due to IP and protecting IP. And if companies would have known that it would have been directly compulsory license, as soon as they would have found the solution for COVID-19, probably companies wouldn't do it. So yeah, I think it lies kind of in the middle, as always. But it would need a measure on world level, and this is also like always a big hurdle because all the countries would have to sit together and come to a solution.
Thank you so much, colleagues. Once again, I would like to thank both groups for sharing the insightful views with us on these important topics. I don't know if Prof, you have any final comments for the day?
It's just next door.
Oh, yes, as always, there's some food next door, so please join us. And also, please feel free to engage the presenters on the topic today. Thank you so much, everyone.